Thanks everyone for joining us this morning. As you've probably just noticed, we are in fact using a new platform, so apologies for the slight delay due to technical issues. This is the first of our employment coffee break briefing sessions. It's a format we've stolen from our insolvency team. They have had quite a significant amount of success with this. And we're hoping to be able to reach a slightly wider audience than our usual HR forums. So some of the people I'm seeing signed on online, I know you're not people who can usually make your way to our HR forums, so hopefully these will be something that you can engage with in a slightly different way. Over the next 12 months or so, these sessions are going to explore the entire employee life cycle. They will usually be at this sort of time in the month. We're aiming for sort of first Wednesday as often as possible, I believe. Starting today with recruitment, we'll go through things like disciplinary, performance, right the way through to termination and post-termination issues towards this time next year. They are deliberately slightly shorter sessions. They're only going to be sort of an hour, 45 minutes to an hour or so. So the idea is to give an overview of each of these topics as we get to them, not necessarily to cover absolutely everything, but to highlight things to be aware of for when they arise in each particular circumstance. As I said at the start, and we've all now noticed, this is a different format. Those of you who joined us during sort of COVID and the end of that will know that we were using Teams and Zoom before, but apparently GoTo is now the go-to. So do have a little explore of the panel, the chat, the questions box. I can see all of those, so feel free to put things in there as we're going through to comment, or if I ask questions, I see most people have figured it out to be able to tell me that they could hear me, which is a good sign. You may have also noticed this session is being recorded, so it will be sent to people who've signed up. It will be used for marketing purposes moving forward, so do just be aware of that. And there's me ticking my GDPR box for you all. So what are we looking at today? First topic that we're coming up with is recruitment, the start of the employee life cycle. So these are the sorts of things that we're going to be covering in the next 45 minutes or so. We'll introduce the key legislation. That will always be the start of this because we are exploring things from obviously the legal aspect. Moving in, we'll talk through the background, the sort of business case decision to recruit, and we'll explore the process in a little bit more detail and where some of the legal pitfalls can arise. And then in effect, the rest of the session will cycle through that process. So we'll touch on job ads, the application CV process, and filtering that down to interview. And then finally, the things that we're doing around final selection and offer, such as pre-employment checks. Throughout all of this, one of the big things we'll be looking at is data protection and compliance, because it is one of the biggest issues that can arise in the recruitment stage. So at various times, I'll be touching on data protection and GDPR. So moving forwards then, the two big pieces of legislation that we're really concerned with at this stage, I mean, the first one to point out on an employment session is it's quite nice not to have to refer to the Employment Rights Act for a change. We're not really bothered with the Employment Rights Act during recruitment because, of course, they're not actually an employee or a worker yet. There are some rights that arise in other legislation at this stage around sort of blacklisting, trade union representation, whistleblowing, those sorts of things, but they don't often arise for most people. So our biggest concerns are the Equality Act, the one we're always conscious of course, from a discrimination point of view. If you don't take anything else away about discrimination today, take away that the Equality Act does still apply at recruitment stage, just as much as it does later during employment. I've put the Data Protection Act on there, and obviously everybody's favourite GDPR in brackets. This is the first stage of being a data processor, the moment you start taking in applications. And of course, it's the first step of you becoming a data processor for what will ultimately become your employee, and therefore processing quite a significant amount of data about that individual. So they're the things we're sort of going to be looking at today, the topics we'll be exploring, and that's the legal framework that we'll be looking at them in context. So let's take a step back and think briefly about the business case and the decision to recruit itself. And I suppose that is the first point we reach here. You do want to have a business case for recruitment. A lot of companies, I know we do it, for example, do have speculative applications, but we're looking at this almost more from the concerted effort to recruit to fill a particular role. That means there's going to be a gap in your business somewhere. Nobody recruits for the sake of it. That is a very expensive way to potentially bring somebody on board who you may not need. And it's a very good way of producing some kind of discontent if you're recruiting someone who sort of 4 or 5 months down the line you realise you don't need. Not a fantastic idea generally. So the first question when you are making that decision is ultimately, what is the role we're trying to fill here? Let's have an idea of the job specification, because that will ultimately guide your decision-making process and the entire recruitment procedure in its own right. You're looking to fill a particular role, not necessarily to bring on a particular person. And the reason that it's important to have such a strong business case around this is ultimately the implications for the business, and particularly the cost. It's easy to think about this just in salary terms, and of course that is a fairly significant expense when it comes to recruitment, and as most people will know, a lot of businesses' salary is going to be in their top 3 overheads, generally speaking. Salary, premises cost, and utilities are usually the top 3 expenses for any business. So particularly for a small business, recruitment can be an expensive exercise because, as I say, it's not just the salary, it is also the national insurance implications, the pension payments that are going to have to be made, and the cost of the recruitment exercise itself. If you're paying an external recruiter, there'll be associated costs with that. If you are recruiting internally and making use of internal HR or managers to run that recruitment process, you also need to bear in mind that you've got a loss of their time and an associated cost there that comes from their engagement in the process. Interviews, sifting of CVs, all of that takes time and is all being done during business hours. I've also put as the third bullet point there the impact on other people, and while that's not necessarily a financial cost other than in the ways that I was just describing, it is one to really take into account when making the decision to recruit. Any recruitment process is going to affect other people. It may well be that you are slicing off part of their job. It may well be that you are recruiting above somebody who maybe feels that they don't need to be recruited above. And it's important that the people who are affected understand why a recruitment exercise is taking place or why that change is being affected, because we don't want that discontent that comes from either of those two things, reducing somebody's job or as I say, recruiting above them when they may consider that they're appropriate for the role. Right at the bottom of that slide, I've mentioned thinking about what that new role will look like and how you're expecting that working arrangement to actually function. Next month's session is going to touch more on the employment relationship, contract status, and all of those sorts of things. But it is obviously a factor to keep in mind when we're looking at what role we're filling here. Are we looking at them as a temporary cover for a busy period? Are we looking at them as a longer term cover, maybe somebody on maternity leave? Or are we looking at bringing in somebody more permanently, more full-time? And on that subject, full-time, part-time, 0 hours, all of this is going to influence how you recruit, the people that you're reaching out to, and the potential applicants that you are going to get for that role. So the big draw from this, the takeaway, the thing to draw out from this, really have the business case for the recruitment, know what you're expecting. But I suppose as we'll look at moving forwards, know what you're expecting, but be open-minded about what comes through the door. Because ultimately we want the best person to fulfill the role for our business. Moving on then, that's kind of the background business case. So what we're going to be sort of looking at moving forward, and I suppose any recruiters on the call, I'm going to apologise now because I've just sort of summarised what is a very difficult job, I know, into 5 words there. But that is basically the recruitment process in a nutshell. We put out the job offer, we screen the applicants as they come in, we narrow them down further through an interview assessment process, and then we look at the final selection and the steps we take to actually affect the recruitment of that individual. The rest of the session will sort of be guided around these 4 things now, and we'll be looking in a little bit more detail at the various legal implications that can crop up at each stage. So let's start with job adverts. It's obviously the first thing that goes out, the first thing that happens, and the first thing that we are going to be exposing ourselves to some kind of risk, I suppose. First question, what do we actually include in a job advert? They should include essential information. The job title is important. People who want to know what job they're applying for, of course they do. Job location, where are they going to be based? What's the basis of their working relationship with you as an employer? Will they in fact be based at your site? Where is that location? What are the options for them working remotely or in some other capacity? All of those are going to be important to somebody who's applying, and all of those should be things that I think appear in your job advert. The responsibilities, fundamentally the job role, what is it that you're expecting this individual to do? And again, it's important to set those out early because we don't want any kind of conflict arising during the rest of the recruitment process, whereby somebody is applying for a job that they don't think is the job that is expected to be done. To me, that's also important later down the line because I don't think there's anything much more frustrating than somebody coming into a job expecting it to be one thing, HR think it's something else, their line manager thinks it's something else. We're creating conflict from the start if we're not sure from application stage exactly what the job role is going to be. I suppose the fourth one that I would always include in terms of what the job role looks like is the qualifications that are expected. Again, for very, very similar reasons. We don't want to be wasting time or creating any kind of conflict situation later on when somebody is applying for a job they're not in fact qualified for. If you've got specific qualifications that are required, you know, I can obviously use my career as a prime example there. List them, put them in there. It's going to reduce time. It's going to reduce the pool of quite literally unqualified people applying for the role. The other thing I think is important to include that I think often gets missed out, particularly when job adverts are done internally, is what the rest of that application process is going to look like. Is it a case that you're going to go first stage, second stage interview? Is there going to be an assessment day? Is there going to be some kind of psychometric test? I think it's important for people to know in advance if they're going to do that. And I think there's two reasons again for this. One, it makes it very clear to the applicant what is going to be expected of them between now and the point of offer. And I think two, as a slightly related point, it will also filter out the less committed, the ones who aren't prepared to engage in a long process in order to actually get the job at the end of the day. You're going to filter out those who are applying across the board for anything and everything. The other one that crops up that I think gets missed occasionally is deadlines for application. It's surprising how many job adverts actually miss this. If you've got a deadline for your application, put it on there. It's incredibly embarrassing both ways when you have to have that email exchange that goes, you've missed the deadline, yes, but your job advert didn't have a deadline on it. As I say, there's no kind of legal claim that necessarily arises there, but this is still about image and avoiding conflict during the recruitment process. Details about the workplace itself I'll come back on to. I think what I want to touch on briefly, just to mention it here about the workplace itself, is this is a culture question, and it's a question of targeting the right people and knowing, without being discriminatory, which we'll come back to in a moment, who your actual target audience is in this recruitment process. Who is it that you're actually aiming to get on board? And what is it about your workplace that you can sell to them? Because don't forget, your job advert is also an opportunity to sell you as a business so that this fantastic person doesn't go to your competitor. There are some discriminatory points I'll come on to in a moment, but I think what's important about talking about your workplace and its culture is to be honest. Because of course what you don't want is somebody coming into the workplace, going through that recruitment process, being recruited, your time cost has been invested into that, and then the workplace isn't what they were expecting it to be. It's very similar to being unclear in the job role itself. The last bullet point on there is one I'm going to ask people on the call to comment on because I know it's a controversial one. If you are somebody who writes job adverts or is responsible for producing them in your workplace, do you put a salary or do you put a salary band on there? Make use of the chat, make use of the Q&A. I'll just pause for a second while people think and contribute how they may wish to on that. But I suppose the question is, are you clear on the salary? Do you put a salary band? Do you keep it vague, or do you just not refer to salary at all and have a sort of to be confirmed or based on experience? This would be a good test of anybody who's actually listening. Yeah, that's fine. I know if people can't find the chat, I can see it in the Q&A. That's fine. Yeah, good. Quite a few people suggesting they put a band or a range. Yeah, a couple indicating dependent on experience, but presumably also subject to bands. Yeah, I think bands is a reasonable way of doing this. I think what my view on this would be is, from a legal point of view, it doesn't necessarily matter what you put there. I do think a salary on a job advert is a good thing. I do think there's an increasing expectation that people want to see that, and applicants want to see it on job adverts. The important thing from salary, I think, to take away is similar to what I was saying about the workplace culture, really. And I think it is important that you want to be honest here. The job advert isn't, strictly speaking, a contractual document. It doesn't create any legally binding obligation to pay that rate. That is obviously the job offer itself and the contracts in due course. But there are a couple of fairly large organisations who tend to recruit people on 0 hours basis who are less clear on their salary range, or who do put a salary range but don't explain clearly that it includes, for example, recalculation of overtime or rolled up holiday. So I think if you're going to put a specific salary on there, then you do want to obviously make sure that the job in due course and the pay in due course reflect that salary. And hopefully that's fairly self-explanatory. So discriminatory language. Yeah, as I said at the start when I was introducing the Equality Act does apply to the recruitment stage. And one of the first places that you can get caught out on this is in the job advert itself. The way these claims are often structured at job advert stage is that the individual feels as though they've missed out on the opportunity to apply because the job advert was exclusionary. So what we'll do, let's have a quick look at a few here. These are all genuine quotes from job adverts, whether I think most of them are in the UK, but I think a couple of them might have been European. I'll work through these slowly because, again, I'll give you an opportunity to comment on them again in the chat or the questions as we're talking through. I'm hoping the first one is about as blatantly discriminatory as anybody would expect it to be. Sunday cashier, female age 20 to 30 wanted. Unless anybody's going to disagree with me, I can't think of any genuine reason why a cashier would need to be both female and in her 20s. It's very clearly discriminatory as a job advert, and that could potentially give rise to a legal claim there by not only women outside of that age bracket, but also basically all men. Yeah, great comment made there in the questions about whether there might be some justification for discrimination, which I'll touch on in more detail at the end of these when we've gone through them. What do we think about number 2? The ideal candidate would be a recent graduate. Yeah, a couple of comments starting to come in there, roughly what I'm expecting. Yeah, the risk there is potentially an age discrimination claim. Obviously, we take on board that anybody can, in fact, be a recent graduate, but the implication there really is that they are going to be in their early to mid 20s as what we think of as a fairly recent graduate, sort of traditionally. Yeah, also an interesting comment that's just come up. Not everyone has the privilege of a university background. Absolutely agreed. There are the traditional professions, which would of course have graduates and degree requirements, but to a large extent, even those now are often being done through other forms of coming into the profession other than the traditional sort of degree routes. So yeah, it's not necessarily discriminatory because class is not yet a protected characteristic, but you're cancelling out a fairly significant section of your job market by saying that you want somebody who's recently graduated without necessarily restricting it by age or by education background. Question, can I say something like this role would suit someone on a gap year? Yeah, you potentially could. You're not necessarily restricting by age there. There's the potential implication that they're going to be sort of 18 to 23, 24, 25, I would have thought. But I don't think it's as clear cut as recent graduate as being potentially age discriminatory. There's always a risk, but I don't think you're necessarily ruling anyone out by saying it would suit someone on a gap year. What about this third one then? Teaching role available for natural German speaker. Do we take any issue with that? Any thoughts on natural German speaker? It depends on the role recruiting for. Yeah, I can see that logic. Anybody else? Yeah, absolutely agree with some of the comments that are starting to come in. The word they mean there actually is fluent. The implication from natural German speaker is that they'd have to be a natural German-born citizen, and there's no obvious reason why that would be the case. If you're teaching German, I think at a very simple level, you just need to be able to speak German better than the people you're teaching. So yeah, to me, yeah, that carries the risk of being race discriminatory because yes, you're ruling out anybody who's not a born German and completely disregarding the fact that German is also an official language of Austria, if nothing else. Okay, what about the last one? We're a young, diverse and friendly team. It's one of those classic ones that comes up when you're describing your workplace culture, I always think, and it's one of those ones that can sound encouraging and engaging. Again, do we think there's a risk there? Yeah. Yeah, got a couple of conflicting opinions coming through, which is good. That's what this is about. Yeah, so let's take the intention here. Yeah, the intention is let the candidate know what to expect from the business. Of course it is. You may well be a young, diverse and friendly team. Yeah, I like the comment that young and diverse are arguably contradictory. Because if you're all young, then yes, there's no age diversity there, is there? Friendly, fine, yeah, call yourselves friendly. I don't think anybody can take any objection to that. Diverse, yes, say it if it's true. But yeah, some of the comments are coming in there. Young is one of those phrases that could discourage certain people from making the application in the first place. And it's so broad. You know, are we preventing people from over 60 applying, over 40 applying, over 30 applying? What do we consider the distinction between young and old here? If they mean that they're a recently formed business or they're a startup, say that. Don't use the word young to describe the business unless it's clear that's what you're doing. But yeah, the implication there is that everybody who we employ is under a certain unspecified age. So yeah, as I was saying at the start, this is really about making sure that people don't feel as though they're missing out on an opportunity to apply. That claim does arise if the advert can be deemed discriminatory in some way. So job adverts, important thing to do, I think, get them reviewed internally, both from a factual and legal or HR perspective to make sure that what's in them is correct and also what's in them is not risking a discrimination claim. If you're in the kind of business that needs to give this more consideration, speak to those with expertise in diversity and inclusion. Two reasons for that. You don't want to be discriminatory. Nobody wants a discrimination claim. But also, if you're excluding people, you're potentially excluding from your talent pool as well, perhaps without meaning to. I'm hoping most people aren't deliberately discriminatory, but the risk is obviously that you are not getting the best applicant for the job. If you use template job adverts, do make sure that they get updated and reviewed routinely, because as we all know, employment law does change quite regularly, particularly what is and is not discriminatory can change on an almost weekly basis sometimes. So do make sure we've got that ongoing legal compliance. So applications and CVs. This is where we start to move into more the data protection angle and the GDPR. Let's be a little bit careful on what information we're processing and how perspective. So I suppose the first thing to do here, think about one of two things depending on your role and what you do. Either what is on your workplace's application form, or if you're not the person who handles that, think what you might put on a CV. Your name, your address, at some point date of birth might apply, although people are more and more conscious about that one, obviously. Covering letter or your CV might imply your background, your school, your university, your qualifications. All of this information is potentially personal and in some cases special category data. So we are a data processor the moment that information comes to us. GDPR, that phrase we're all familiar with. Personal data must be processed lawfully, fairly, and transparently. So to me, this means informing candidates about how their data is going to be used before they give it to you. And the ideal way to keep yourself as safe as possible on this is to get their express consent through a privacy notice, through a form as part of the application process that details how their data is being used and asking them to consent to that being the case. All of this means giving consideration to the overall process to make sure that you are compliant with data protection law. First question I would ask is how does that application process come through the door? Does it get sent to a HR @ email address, an info @ email address, a reception @ email address? Any one of which could have fairly wide access across your organization and could be being seen by someone who doesn't need to see it. That, of course, is a risk there in relation just to the pure data itself. But if as part of that application process, the candidate has also disclosed a medical condition, for example, you've got an extra duty to protect that as special category data from people who really do not need to see it. There are consent privacy notice templates to answer the question that's come up. If you want to ask me about them, please do kind of drop me an email afterwards. It's not something I'm going to be able to easily share as part of this session, but they do exist. Lots of people use them. They don't need to be personally drafted necessarily. Moving back on the kind of subject of data protection and how the application is reviewed is then kind of your next question. Who looks at it? Who sees it? Who needs to see what information at that stage? There's certain data that can be redacted. There's certain information that can be anonymized to make sure that whoever needs to process whatever part of that data doesn't necessarily see all the other information. Best example I can think of here is if you're using external providers to do some of the background checks that we'll come on to later, they don't need the entire CV, they don't need the entire application to be able to do that. They certainly don't need to necessarily know about a potential medical condition or disability, for example, to run a reference check. We'll touch more on GDPR later in the session, but I think at application stage, as I say, the big thing is to know who it's coming to, who sees it at that stage, and then what is done with it, and to ensure that any applicant or candidate knows what process that is and has specifically consented to that being the case. Moving on then to shortlisting, and I'm going to sort of overlap shortlisting, and the next slide is on interview and assessment process as well. A lot of the guidance I'm going to give from a legal perspective here pretty much overlaps on these two. The big one is the use of objective criteria here. Anything subjective does allow for the risk of bias, and the moment we've got the risk of bias, we've got the risk of discrimination because a decision is being made on something that's not necessarily the job itself. So objective criteria when you're both sifting and when you're doing the sort of final decision making around making an offer itself. We're looking at qualifications, we're looking at skills, we're looking at relevance experience. And really the best way that I can think of to approach these from a how safe can we be legally point of view is this is the complete opposite of a redundancy process. Those would be objective criteria that are skilled on that are assessed on a numeric matrix. Do exactly the same at this stage as well. Don't sift out on anything that could be deemed too subjective, simply because if you end up with a discrimination claim, the onus will eventually come on you to prove that what you've done was not discriminatory. And the more subjective you are in that decision-making process, the harder it's going to be to show that the decision wasn't discriminatory in the first place. Objective criteria is a really helpful defense when it comes to discrimination claims around recruitment and around redundancy, which we'll come on to at some point in the next 12 months, I'm sure. The two real areas where the risk of unconscious bias kick in, and I'll cover again unconscious bias in a bit more detail in a second. Really what you want to be looking at here is who's doing the sifting process and where is it done. Is it being done internally? Is it being done externally? Are you aware of the potential for unconscious bias where it arises? And are the people who are doing your shortlisting, your sifting process, aware of their own potential biases that may be cropping up? We'll talk about that a little bit more in a second. I just wanted to highlight it here. For now, what I'm more interested on this page is the use of AI, which I think is something that's already been done quite heavily in sort of recruitment and other forms of application process. So I am curious, is there anybody who is using some form of AI or automated sifting at that sort of CV application stage? I'm getting a couple of no's. No's, but the recruiter does, yeah. Nobody admitting they definitely do use it. That's interesting. Yeah, as a recruiter, we don't, yeah. Those of you who don't, if you also want to add why you don't. Yeah, that's good logic. Takes out the personal element. Yes, it absolutely does. Yeah, couldn't agree more with you on that. Not considered it, not aware of the opportunities. That's interesting. Use AI to job descriptions. We do use a CV parsing tool to extract data. Yeah, fair enough. Personal element. Yeah, I do think applicants want a personal element when it comes to this. I think my biggest concern about the use of AI is a story that actually came out of, I think it was one of the American universities. And what they'd done as part of their application process was it was introduced AI sifting of the job applications. And what they had done in order to do that was filtered into the AI system every successful applicant who'd ever made their way through the university. You don't need to know much about American history to know that the majority of people who had gone through that university were white, wealthy men. And what that meant was that in the 2020s, this automated system was still filtering out anybody who didn't have what it perceived as a white male name. And the basic risk there is that AI can be trained or train itself to be discriminatory. And while that's not actually an issue that's necessarily been tested yet in court, I think the serious risk is that the employer has allowed a discriminatory decision-making process. And I can only imagine how an employment tribunal judge would react to discovering that an AI system was filtering out every black woman's CV at shortlisting stage. I think very much the onus there would be considered entirely the employer's fault, despite the fact that it's an automated system that's done it. But yeah, on a sort of maybe non-legal level, I agree with some of the comments that are coming through. And as we said a moment ago, it's very much the case that applicants do like to feel as though the CV they spent hours working on is actually being read by a human. And indeed, the application form is also being read in that way. But yeah, there are of course benefits to using CV parsing to draw out key data. If you're looking for someone who's got a particular qualification, then yes, filter out the ones who don't mention it on their application. I can absolutely see the sense in that, providing you know that is all that is being filtered out. Fine, but yeah, I mean, just again with shortlisting, with interviewing, and with assessments, is to have this sort of standardized objective set of criteria that you're working against. It helps make the process transparent, it helps make the process consistent, and it helps that all candidates are being then judged against the same criteria if you had to justify it later because somebody tried to argue your decision-making process was discriminatory. Document your process so you can evidence decision making if you're ever criticised on it. The criteria should be documented somewhere so that you can always go, well, no, look, this is what we were assessing against. The decision itself, who made it, and their justifications for doing so. The other thing that I will mention, and again, it overlaps both kind of the HR and the more legal side, is even at this stage, to a degree, feedback to unsuccessful candidates. It will help stave off a discrimination claim if they think there might be one, and people like feedback. People like to know why a decision has been made about them. I appreciate if you get several hundred CVs for one job role, you're not going to provide personalised feedback to each one. But if you are filtering and sifting out on the basis of not having a certain qualification, that's a fairly generic message that can go out if it has to. Okay, question that's just cropped up. Is there anything we need to be aware of when receiving CVs from agencies? From this point of view, not necessarily. In terms of kind of the discrimination angle, I'm assuming that's the question. I would suggest not, although what you do want to do is probably keep an eye on what you're receiving from agencies, because obviously there is a risk that the agency itself is consciously or unconsciously discriminating. I don't think there's a direct legal risk to the end employer in that situation, but again, this becomes a thing about reputation and avoiding conflict as part of the recruitment process. In terms of the other legal aspects of receiving CVs from agencies, don't forget GDPR cuts both ways. When it first came in, everybody got a bit obsessed with reading each other's data protection policies and procedures that sort of applied to the sharing of information about people. Yes, there is a responsibility at that point because you've received that personal data, you've just become a processor of it. Make sure that it has been sent to you lawfully, fairly, and transparently as well. So next stage where we have issues, I know everybody gets thrilled about pre-employment and background checks, so we will just touch on them very briefly now. I'm hoping most people are at least caught up on right to work checks, which I'll come on to part way through this. The purpose of background checks, three big reasons really. There may be legal compliance reasons that you have to do it, so the right to work is a prime example. Your business or industry may have regulatory checks that you have to carry out, so DBS, what used to be CRB checks, is a good example of those. But the basic reason that applies to everyone is ensuring that you are bringing on board safe and competent staff who are not going to cause damage to your business, and indeed who are who they say they are. The main takeaway from doing any kind of pre-employment check is to make sure that you are fair and consistent in what you are doing and with whom. Short answer is, if you're going to check people in a certain way, check everybody in that way, unless there's a compelling reason that you don't need to. So the first sort of big one, DBS checks, disclosure and barring service, what used to be CRB checks, necessary for some regulated professions and for any role that involves young adults, young people, vulnerable adults, or any overlap thereof. DBS checks are almost always, in my experience, done through a third-party provider because that ensures the best legal compliance and ensures that information being passed from the DBS back is done in the correct way. It's the individual who receives the full certificate. You, of course, just receive a notification if there's anything you do need to be aware of. You should not see their full DBS check. Again, if you're using a third-party provider for these things, most of them have got their data protection policies and procedures in place, but don't forget that you need the individual's consent to share in the first place, and to ensure that if you're using a third-party provider, they are a reputable one with the appropriate protections in place. The overlap with DBS is the Rehabilitation of Offenders Act, which I know the recruiters in particular will be familiar with on here. In effect, what the Rehabilitation of Offenders Act did was it said, okay, somebody may have served a prison sentence, somebody may have a criminal conviction. This shouldn't stop them later down the line from getting a job or reintegrating into society. It is a form of discrimination to refuse to engage somebody at work, excepting for a handful of regulatory exceptions, because they have what is known as a spent conviction somewhere on their record. You can't do it. You can't ask people whether they've got spent convictions unless you're recruiting for certain roles. And do just bear in mind, those of you to whom this regularly applies and you do deal with this, the regulations have just changed to shorten that period of notification for spent convictions. For most people, you're probably not going to pick up on this very often, but as I say, do just bear in mind that it's there. If you become aware of a spent conviction, that is not something that can necessarily influence your decision to recruit. Right to work checks I won't do in too much detail because I could easily talk for an hour on those, as we all know. The obligation on you is to ensure that everybody who works for you has the legal entitlement to work in the UK. That has to be documented. You will have to keep records on this. There are criminal and civil penalties available to the business, the employer, for failure to comply. Nobody wants to get caught out with sort of tens of thousands of pounds worth in fines for recruiting somebody who cannot legally work in the UK. Depending on who that individual is, where they're from, what right there is, will depend on what information you receive from them. So ensure you've got that documentation. The government online checker for this is quite good. The important thing from a discrimination point of view on right to work checks is obviously do it for everybody. Don't just check people who may not have automatic entitlement to work in the UK by virtue of having been born here, for example. Question just come in on spent convictions. Yes, as I said, there are some accepted industries where you can consider spent convictions. Again, I wasn't going to go through the entire list of them here, but yes, care is one of them. The legal profession, finance sector, all of those where there is an additional duty. And if you're recruiting at director level, directors' disqualifications will also appear on a DBS, things like that. Just moving on, I will come to any outstanding questions at the end because I want to get to the end of the presentation first. If we've got time, we'll do questions right at the end. Just want to touch briefly on equal opportunities and diversities in a more general sense. There is a value to diversity in a workplace, of course there is. Where that really comes from, I think, is bringing different experiences, bringing different backgrounds, bringing different expectations into a business, the ability to share ideas, the ability to cater to different audience, different markets, depending on the nature of your business. Everybody comes with different perspectives, everybody comes with different ideas about how things do and don't work. So earlier on when we were talking about maybe social background, that is as much an element of diversity as the things that fall under the Equality Act. You don't necessarily want to just be focusing on the protected characteristics when you're talking about diversity. Within recruitment, obviously the biggest risk, as we've been saying all the way through, is that there is a risk of discrimination. I've highlighted positive discrimination there, sort of the other way round. All I'm going to say on sort of positive discrimination in situations where you sometimes are allowed to prioritise based on a protected characteristic is to A, be very, very careful with it, or B, preferably steer clear of it. The idea of this kind of being able to target particular underrepresented groups, really this is only designed for situations where you have two otherwise perfectly equally qualified candidates and one of them happens to be from an underrepresented group. you can prioritize that individual in theory. It's a very difficult argument to justify because, of course, recruiting this person at director level because they are a woman and they are underrepresented on our board is inherently saying you're not recruiting the other one because they're a man. It is a potential defense, but it does rely on there being absolutely no other difference between these two individuals. And as we all know, that's very, very rare. You don't often come up with a situation where you've got two perfectly qualified and otherwise perfectly recruitable candidates that you have to make a decision between. The other thing to talk about with equality and diversity, if it applies to you, if it applies to businesses of your size, structure, or sector, is that you may have reporting requirements that will crop up. Gender pay gap, and increasingly other kinds of pay gap reporting are all going to start being relevant. If you are a business of that size, I won't go through these in detail because it will take forever. Do be aware of your reporting requirements. Similarly, if you're in a regulated sector and your regulator requires it, you may also have reporting requirements there. Absolutely agree with some of the comments coming in. Yeah, if you hire 10 people who are from diverse backgrounds and they have 10 different ideas, you suddenly have 100 ideas. Absolutely right. There's huge benefit to diversity. I'm going to touch, as I said, on unconscious bias just very quickly. This is something many of us will have looked at before. Unconscious bias, an automatic, unintentional, and often subconscious judgment or stereotype. It's important to know everybody has these. We're all human, and the way that we interact with other people is always based on our prior experiences. There is no way of getting out of this. It is how the human mind works. It's not the same as being consciously racist, sexist, homophobic, whatever, but the unintended consequences of unconscious bias can be discriminatory in effect. The important thing with unconscious bias, particularly in the recruitment stage, is to recognize that it is there. The fleeting assumptions or judgments that we sometimes make based on people's appearance, the way they speak, the way they write, will all have a knock-on effect on how we then deal with them moving forwards, whether we're aware of it or not. It's not necessarily just in relation to the protected characteristics, but that is obviously where the risk comes from. An example that was used in a training session that I was on once is you're in the high street and there's a gang of hooded teens walking down your side of the road and you cross over. That is an unconscious bias. You don't know that they're up to no good, you're just assuming they will be. Could be age discriminatory, I suppose, but the point was it's not necessarily just protected characteristics. Ways of mitigating unconscious bias in recruitment that are increasingly being used, blind applications or redacted applications in certain ways. It draws back to some of the data protection stuff we were discussing earlier. Only share with people what needs to be shared with them. If they don't need to know this person's racial background or gender identity, don't share it with them. It's not necessary to part of their decision. Having more diverse interview panels, yeah, as we were just saying, if 10 staff from different backgrounds all come with 10 ideas, then you've got 100 different ideas. If you've got 3 people from different backgrounds on a panel, you've got potential unconscious biases balancing each other out, and different ways of approaching the recruitment process. As we were saying before, structured and objective interviews that are based around the job requirement. Ultimately, the point is recruit for the role. Get the best person for the job as best you can, regardless of who they are. Okay, disability and reasonable adjustments. I'm conscious that we started late and I'm getting very close to 11 o'clock, so we will do reasonable adjustments in a full session that will be dedicated to this later on. The thing I want to draw out here is that the duty to look at reasonable adjustments does trigger during the recruitment stage. Candidates with disabilities, you need to be considering that reasonable adjustment angle. Obviously, this only triggers where you've potentially got knowledge of the disability itself. The problem that you potentially have is the first time you meet an individual might be the first time that you become aware of their disability. And we don't want this embarrassing situation to crop up where they turn up and can't access your office for some reason. We know you obviously can't ask the question, do you have a disability? That carries risks with it. What you can ask as part of the application process is whether the individual feels that an adjustment would need to be made to the procedures for them for any reason. That opens the door for them to tell you to give that information or for them to choose not to. Other than that, the duty, which as I say we'll cover in more detail in a later session, is only to make reasonable adjustments. It's only to make the things that you can viably make in that situation, given the resources available to the business. I think we've covered most of what I wanted to on GDPR and data processing. So there's that key phrase again: lawful, fair, and transparent. The recruitment process, as I said earlier, it is data processing. It is personal and sometimes special category data. Your lawful basis will ideally be, as we said, the person's express and freely given consent to process that data in each way. In theory, you could argue compliance with legal obligations, you could argue performance of a contract, but I think consent is a lot safer, and if we're getting that at early stage, that helps. Candidates should always know how their data is going to be used, who it will be shared with, and why, so that they can give their clear and unambiguous consent to it being used in that way. As we've been saying throughout this session, consider the external handlers of data, make sure that they are also DPA, GDPR compliant in how they are doing it. And as I said, that your consent, the candidate's consent is given for it to be shared with them. Consider minimization, only share and process the data that you actually need to, and only retain data that you actually need to. And as I said there, don't forget there are two other main rights: right of access under a data protection subject access request, and the right to be forgotten unless you've got a good reason for sharing, for holding on to their data. Retain the application information only for as long as is absolutely necessary. Right, that was about 5 minutes quicker than I wanted it to because of our late start, but if people are happy to hang on, I'll have a look at some of the questions that are cropping up and answer those I can, but I'm also conscious that we did say 11 o'clock, so if people need to leave, by all means, feel free. I will not be offended. What I will just say quickly before I come on to questions, next session is likely to be the first week in December. As I said at the start of this one, I'll be looking at contracts, contractual terms, and employment status. I will hang around for 5 more minutes and look at some of the questions that have cropped up, but that is the content. If anybody needs to leave, totally understood. Thank you for joining us. Covered the privacy notice question, didn't I? Anything we need to be aware of from CVs? Yeah, care industry, as I said, is one of those examples where we can consider spent convictions. There was a question from someone who's left about unspent convictions. Yes, they can be asked about, but again, you want to make sure that you've got a good reason for asking that. If you don't need to know about unspent convictions, then don't ask. If your office isn't compliant, you're advertising for an office-based role, how should you handle this? Very, very carefully. There's no kind of easy answer I can give that. What I would do is I would ask the question potentially during the recruitment stage, whether they feel they would need any adjustments to the recruitment process itself in the first instance. If they come back to you and say, I'm in a wheelchair, I can't access the first floor, then I think at that point you have to be honest with them and say, this is our situation, and be prepared to have that discussion. It's not discriminatory if the adjustment they need isn't reasonable, but don't forget the onus is always on you to prove that if a claim is brought in the long run. What else have we got? Is there a legal time limit to hold on to records? No, not really. The obligation is on you, depending on how long you're holding it, to justify that if somebody takes offence with it. There may in some sectors be regulatory reasons why you need to hold on to either applications or employee records, so bear those in mind. But the simple answer for GDPR purposes is only as long as is absolutely necessary. Retaining data of ex-employees, yep, in a sense the same question, Richard. Yes, you could keep it beyond then if you feel you absolutely need to, but make sure you've got a justification for doing so. Okay, any other questions anybody had or anything they think I've missed? No, right, if not, I'll finish the session there. Thank you everybody for joining, and yeah, see you next month, hopefully.